All right, hi everyone. Hello. Welcome back. Hope everyone's doing well. Yeah? All right, let's see. Any questions from last class? We went through a lot of stuff in the last class. A very good discussion. Anything in your minds about gender discrimination? Houston, Virginia, any of the above? No? Okay, so let's move on. The next topic we will cover, and we'll probably spend a couple weeks on this, of the 14th Amendment. The Due Process Clause of the 14th Amendment has been probably one of the most controversial aspects of constitutional law because of one word in that amendment, and that word is liberty. It's a term that the Constitution does not define, and it's a term that courts at various times have taken it upon themselves to give meaning to give substance to. So today we start with a history of what's often called substantive due process, the idea that the Due Process Clause protects more than mere procedures, but protects substantive actual rights. And we start with one of the first instantiations of it, which was what's often called economic liberty, the right to contract. We'll continue in next class and the one after, on what may be called familial rights, the right to raise your family, the right to education, and even the right to contraceptives. This builds up to a crescendo when we discuss abortion and whether the 14th Amendment protects indeed a right to privacy and a right to an abortion. The class then builds up to a crescendo that wasn't, of whether the 14th Amendment protects a right to same-sex marriage. Because as you'll see when you read a Bergefell, the decision isn't clear what clause it's talking about. And the court does not say that you have a liberty interest in marriage. They say some other stuff that we'll talk about in a few weeks. All right, any questions before we get started? All right. So before I go too far into the 14th Amendment, I want to discuss a short story called The Lottery. You want to read The Lottery? Daryl, you know anyone else? It's a creepy story, right? Sure. So let me tell it, and if I miss anything, you guys just fill it in. So there's a small town with about 300 people. And every year on June 27th, the children start gathering stones, okay? And they start, hoping that they'll have a good harvest for the crop. The evening of June 27th, the mayor of the city puts in a furnace one slip of paper for every family in town. So there's, if there are 100 families, there'll be 100 slips of paper in this furnace. And he marks one of the slips of paper at random, totally random, with a piece of coal. So there's a black mark on it. So the next morning, every family in the town draws a slip of paper. And then one family, the Hutchinson household, drew the piece of paper with the little black mark on it. Okay? The next morning at 10 a.m., they go to the Hutchinson household, and there are 5 people living there. And they put in a box 5 slips of paper. And each member of the household, the mom, the dad, the brother, the sister, draw one of these slips of paper. And they find that the wife, her name was Tessie, drew a slip of paper with a black marking on it. As soon as the marking is found, everyone goes outside, and everyone in town starts throwing rocks at Tessie until she dies. She's stoned. And as Tessie is being stoned to death, she says, quote, "It isn't fair. It isn't right." And she's died, and she dies. Daryl, why did I tell that story today? Why did I choose to spend 5 minutes talking about this story? What's the think of Tessie's last word. She says, "It isn't fair. It isn't right." Was there anything unfair about the process by which she drew the slip of paper?
Not about the process, but about the whole concept of it. Is it right? It's fair. Because everybody's part of it, but it's not right because the underlying justification is. Yeah.
All right, anyone else? Anyone else? Any thoughts on this story? Why did I tell it, Michelle? Why did I tell this story?
So procedurally,
And mind you, she watched my videos from last year apparently, so she knows the answer. But go for it.
procedurally, it was correct.
Yeah.
The problem with there was substance,
Okay.
meaning there had to be a connection.
Okay, good. So the book, which is written generally quite neutrally, I think in this chapter it goes a little bit away from its neutrality. Discusses the due process clause of the 14th Amendment as guaranteeing process, right? The idea is if the government wants to take your life, your liberty, or your property away from you, they must afford you fair processes or fair trials. And I tell this story of the lottery, which is a short story you can read in a few minutes, because it exemplifies, I think, quite well why fair processes by itself isn't always sufficient.
Why did they stone anyone in the beginning?
Why? Why wouldn't you stone anyone from the beginning? What's the problem with stoning anyone?
Was it like a ritual? Was there like a sacrifice?
Who's to say that these people shouldn't stone someone? Maybe they wanted to make the harvest better. Which is, if you read the story, this helps the harvest. There's a sacrifice. But what's wrong with that? What's wrong with sacrificing a person? Nothing wrong at all. Was there anything unfair about the process they used? Was it the lots were randomly drawn, right? So the papers were randomly put in there. Is there anything unfair about this?
It's fair.
Okay. So what the story tries to get across, and actually my friend Tim Sandifer uses this example in his book, Conscious of the Constitution, which I encourage you to read. But due process of law doesn't always have a purely procedural context. Going all the way back to Magna Carta, an aspect of due process might be called whether it's fair or whether it's right. The idea that there might be something substantively wrong about throwing rocks at an innocent person, even though all procedures were followed, right? The notion that due process affords an opportunity to judge, is this right or wrong? Is this a reasonable action, right? Brian thinks there's absolutely nothing unreasonable about stoning to death a woman to get a fair harvest. Okay, well, I'm glad you're not on the course. But I think most people would say subjecting this poor woman to this procedure. Angela, okay.
Question.
Yeah.
At what point does that, I don't know, infringe or whatever on the societal right to sort of govern themselves?
Oh, and this is the beautiful concept we have here, right? Once we start asking, is this procedure fair, Angela, the question is, who gets to decide?
Right. My point
And
that I was thinking about, who gets to decide?
Yes, okay.
In terms of the culture, this is like, the
Yeah.
societal norm.
So if the people in this small town are okay with stoning the woman to death, then what's the problem?
And culturally, right, a lot of that has significance. We worked a couple of cases when I was
Honor killings?
Honor killings.
Yep.
Where these guys did things, and to them it was perfectly within their belief system. She did this, and so we killed her. What? But in their brain, I mean, they didn't try and hide it, try and defeat. To them,
We have these in Texas too, by the way.
that was the thing.
So this is the question, right? Angela raised a very good point. Who decides? Who decides if a process is correct? Now, can a court decide if the process is procedurally fair? Sure. They say, well, they put 2 slips with a black dot on it, right? Procedurally a problem, right? Or the court can say, you know what? They rigged the ballots, right? They stuffed the ballot box. Courts have very good skill sets to decide if a process is procedural and fair. But once you say, is it substantively wrong? Then you're taking the court's judgment of right or wrong in comparison to the people, the elected democracy's right and wrong. And this is why due process has been so controversial. Whether courts are invalidating laws that regulate the number of hours that people can work, or whether people can send their kids to a private school, or whether married couples can take birth control, or whether people can engage in homosexual sodomy. These are all questions on which people disagree, whether this should be allowed or not. And with the Due Process Clause, the courts have seized for themselves a license to intervene and say, no, 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 this law enacted through the democratic process, that law is wrong. We'll decide what's better. Good answer? Okay.
Thank you.
And what, do you actually honor killings here in Texas? Did you see those? Those are really messed up. Yeah. If anyone doesn't know what these are, in certain cultures, if a woman engages in an act of promiscuity or unchastity, it's actually incumbent on the family of the girl to kill the girl rather than bring shame to the family. There's a book, I think, a movie called The Stoning of Soraya. Whenever you hear this, it describes an honor killing in Afghanistan in vicious details. These are pretty bad things.
And the conflict is, at least in suburbs like Leeds City, the girls are raised in, you know, they go to
Western, yeah.
CISD, regular school, regular clothes, but their parents are from, you know, Syria, Africa, you know, whatever it is. And that clash of cultures is strong.
Right. Yeah. So we have here then two notions of due process, and we'll discuss both of them. So on the one hand, we have what may be called procedural due process. Procedural due process. And the classic example of this is if, say, you're a tenured professor at a state university, which I am neither, right? If the state wants to fire you, they need to give you a process first. They need to give you a hearing before they take it away. Procedural due process refers to the process that is due before your life, liberty, or property is taken away. Procedural due process is easier. We don't spend much time on it. The tougher one is indeed substantive due process. The idea that this word liberty reflects substance. There's meat there. And then what sorts of rights can the state not take away from you? Now, one of the more complicated aspects is when we're talking about substantive due process, if a right is so important, the courts have effectively held that no amount of process can save it. What can I mean by that? Let's take an example from later. Let's say we have a law that prohibits the provisioning of birth control, right? What happens if they say, okay, you can get birth control if you go to have sex birth control first. You get your process, right? You have your process. You have a hearing, and the judge can decide whether or not you get your pills. The general notion is if the right is so important, perhaps so fundamental, that no process could ever justify its infringement. So generally speaking, in the case we have here, once this sorts of liberty interests are identified, no hearing will save it, right? No process will allow the government to take it away from you. It's effectively a guarantee. So a substantive due process, it's not just that you have a right so long as you have a hearing. It's that the government cannot even afford you a hearing because this thing is so important. You don't have to justify to the state why you need contraceptive. Okay? But herein lies a difficulty. As a court has held in many contexts, the justices are responsible for deciding what the 14th Amendment means. You have this word liberty. And I'm going to read you a quote from Abraham Lincoln from one of his famous addresses. Abraham Lincoln said, "We all declare for liberty, but in using the same word, we do not all mean the same thing." I said it one more time. Lincoln wrote, "We all declare for liberty, but in using the same word, we do not all mean the same thing." And I'm sure if I asked, there are 50 of you in this room, what does the word liberty mean? I'll probably get 60 different understandings, right? And Lincoln has this great image of the shepherd, the wolf, and the sheep. And liberty often depends on your perspective. So Lincoln says, "The shepherd drives the wolf from a sheep's throat. The sheep thinks the shepherd is the liberator, while the wolf denounces him for the same act as the destroyer of liberty." So if you're the sheep, oh man, you love the shepherd. He's your liberator, right? But if you're the wolf, the shepherd's a tyrant. He's stopping you from being free. And Lincoln was using this as a parable of slavery, where the masters who owned slaves effectively viewed the Civil War as oppressive, as tyrannical, that they're taking away their property. You recall Dred Scott, that's indeed what it was viewed as. But from the other perspective of the freed slave, indeed the liberator was coming to free them. Lincoln was using this shepherd imagery as a metaphor, and a pretty good one at that. So throughout the entirety of the post-14th Amendment history, courts have grappled with giving substance to this phrase, liberty. Now, I want to step back from your book, because I think your book is pretty good usually, but drops its neutrality a little bit too much for my taste with this chapter. And they make it seem like it's absolutely unconscionable that the word liberty in the 14th Amendment has meaning, that judges are simply ill-equipped to make these determinations. And I think the book goes a little bit too far in this. Because you have to recall, the 14th Amendment was ratified based on history of people being denied a lot of freedoms. They weren't merely just being denied, the right to vote and the right to, the right to, equal protection. They were being denied lots of freedoms: the right to bear arms, the right to own property, the right to sue and be sued, the right to work on their own terms. And you recall we did something called the Civil Rights Act of 1866, which was vetoed by President Johnson. And the Civil Rights Act of 1866 lists a lot of rights that the freedmen would now receive. And the word liberty, I think, can be read against this background principle of what were the sorts of rights that were recognized as important at the time of the ratification of the 14th Amendment. Now, when we did Slaughterhouse, I explained to you that the main clause, right, the clause meant to do the heavy lifting, was a privileges or immunities clause. And this was meant to protect a host of substantive rights. The Supreme Court read PRI out of the Constitution. In the Slaughterhouse cases, that doesn't mean anything, just kidding. But an interesting thing happened. After PRI was knocked out, the courts began shifting down the line. So they went to the Due Process Clause. And many of the various sorts of liberty interests that the court has given to the Due Process Clause will be much more at home in the Privileges or Immunities Clause. And it's unfortunate, but that's how it works. But it's safe to say that the 14th Amendment did protect certain aspects of fundamental rights, certain substantive rights. And it wasn't crazy for the idea that courts would be the ones to enforce them, okay? So there are two thoughts here, right? One, if the framers of the 14th Amendment understood certain liberty interests to be inherent in the 14th Amendment, then it wouldn't be so crazy for courts to start, enforcing them and invalidating laws by states that infringe upon those rights. But by the same token, if judges start to manufacture rights that have no grounding in what the 14th Amendment was understood, well, then it's a lot harder to justify that anti-democratic principle. And this is my own more of a personal opinion, but generally speaking, it's wrong to say the 14th Amendment didn't protect substantive rights. But I think the book does a better job explaining how the courts have failed to cabin or constrain rights that were fashioned. And this leads to perhaps uncomfortable conclusion that certain rights, like liberty of contract, may be protected by the 14th Amendment, but other sorts of modern rights, for example, contraceptive or whatever else, which were unfathomable at the time of the framing, perhaps aren't. This leads to a lot of anomalies. The court's substantive due process cases are not a clear line, and they don't make a lot of sense when read in whole. So for this lesson, you'll need to go kind of case by case by case. Okay. All right, any questions about that? Yes, ma'am. Oh no, what was my second thought? I don't remember. I don't write down what I say. You just go. Oh God, yeah. Thank you. Yeah. So the first sense, right? If courts are actually trying to understand how liberty was understood in the 14th Amendment's framing, there is some pedigree there, right? But by the second token, if they're simply manufacturing various principles of law, it becomes harder to ground that in the 14th Amendment. The Brown Court, though, seems to have no problem. They said, we don't really care what the 14th Amendment was understood. There were segregated schools. The only difference there is that the word equal protection is in the Constitution, which suggests equality of something, right? The word liberty is not defined, and it provides a much broader license for courts to enforce what is not there. So while a lack of originalism for equal protection may be more understandable, with respect to due process, it gives courts a very, very, very wide scope of authority. Oh, you're welcome. Yeah, you shouldn't remember what I say. I kind of go, and eventually, usually it winds up in the right place, I think. Okay. All right. So actually, the phrase "due process of law," it's mentioned in your book, stretches all the way back to Magna Carta. And there was actually one provision of Magna Carta that basically said you can't be deprived of your liberty or property unless it's by the, quote, lawful judgment of your peers and by the law of your land, the law of the land. You cannot be deprived of property except by the so-called law of the land. This idea of law of the land was very significant because historically the king was the law. Like, remember Mel Brooks in History of the World? I am the king, right? The king was the law. There was nothing above the king. The significance of Magna Carta was they said, you know what, king? There is something above you, the law. And if you want to take away my property, you must do so in accordance with the law of our land. Okay? That there was some predictable, regular, ascertainable law that a person of intelligence could know what the law is and what's expected of them. And the reason why this is important is this phrase, law of the land, became synonymous with due process of law. That is, the process that is due to you if the government wants to take away your life, liberty, or property. And this developed all the way from Magna Carta in 1215 through Lord Coke and into the American Constitution. The notion that if the government wants to take away something of yours or imprison you, there must be some check upon that. It's almost a separation of powers doctrine, which was mentioned in your reading. That way the king would be making all of the determinations of how rights are afforded. Okay, come with me so far. Now, one of the first, now here the book makes a very common quasi-misstatement, which I'll slightly push back because I like the authors. So the book says here that the first instance of substantive due process is in the Dred Scott decision. You'll recall that Chief Justice Tawney, among other arguments he made, he said that slaveholders have a property right in their slaves, and that would actually violate the due process rights of the masters for the states to prohibit slavery. And the book makes it seem like this was the creation of substantive due process, that this doctrine had never existed before. That's kind of true. So in terms of the Supreme Court, this for sure was the first time the Supreme Court had applied the doctrine of substantive due process to the Fifth Amendment. That much is true. But there are court cases going back to England in the 15 and 1600s where courts actually step in to invalidate laws as violating due process or violating the law of the land. Indeed, in the 1600s, British courts would often step in and say that this law violates Magna Carta, that it prohibits some sort of liberty interest in contrast to the law of the land. So Dred Scott didn't create substantive due process, but it was one of the first prominent applications of it under the Fifth Amendment to the Constitution. Okay. Any questions on that so far? Okay. So moving forward, after the ratification of the 14th Amendment, you'll recall Slaughterhouse was a situation where the city of New Orleans passed a law saying that if you're a butcher, too bad, you're out of business. Only butchering goes on in this location. Okay? The butchers brought a lawsuit saying that violates our right to earn an honest living, what might be called the liberty of contract. If I want to make a contract to be a butcher, I have the right to do so. And they brought this under the Privileges or Immunities Clause. Again, there's a pretty decent argument that the Privileges or Immunities Clause is meant to protect a right of contract. I think I'm persuaded by it, but you don't have to be. The court rejected that, saying no. Justice Field in dissent specifically said 14th Amendment guarantees a right to contract. So after Privileges or Immunities was knocked out, they moved on to the 14th Amendment's Due Process Clause. And in a series of cases in the 1870s, 1880s, and 1890s, the Supreme Court began to sketch out this doctrine of liberty of contract. And what you have to know about this era, what's often called almost the progressive era, is that states began experimenting with laws regulating industry. Okay, before the 1870s, industry wasn't really a thing. There wasn't really an industrial revolution yet. States had very little interest in controlling how people ran their businesses. There were no wage laws, there were no hour laws, there were no safety laws. Everything was pretty much whatever you wanted, went. It's often called laissez-faire, but I don't particularly like that phrase, but it is helpful here. Towards the end of the 19th century, beginning of the 20th century, states began to experiment with different forms of labor regulations. And one of the byproducts of doing this was that businesses that historically had been able to do whatever they wanted now have to deal with a host of increasingly encroaching regulations. So what did business owners do? They turned to the 14th Amendment. They turned to the Due Process Clause. And they argued that one of the liberty interests protected by the 14th Amendment was the right to contract, and that the state could not unreasonably burden this right to contract. So in one case, Munn versus Illinois, 1877, the court held that when the state regulates private contracts, right, when the state regulates private contracts, the judiciary has a role in deciding what is reasonable. Okay? The judiciary has a role of deciding what's reasonable. So it's not enough that a regulation of private contracts is enacted by the democratic process. Here, the courts were injecting for themselves a role of deciding whether, in fact, it was reasonable. In the big case, 1897, Allegeyer versus Louisiana, Allegeyer, Allegeyer versus Louisiana. The state of Louisiana passed a law saying that if you wanted to sell insurance in Louisiana, you had to open up an office in Louisiana. Okay, I'll start going around. What was I up to? Who was last?
I think that
Okay. Louisiana would enact a law saying that if you want to sell insurance in the state of Louisiana, you need a store in Louisiana. Oh, you gave the exact right answer. Good. So the real answer is they wanted to prevent out-of-state insurance companies from interfering with the business. By the way, I don't mean to go back to Obamacare, but I will. Do you know why you can't buy insurance across state lines? Originally, it's to protect local insurance dealers. Yeah, this stuff exists. So Pamela, you're exactly right. The real reason why is to basically block out-of-state businesses. But when they went to court, right, what do you think the reason they gave to defend this law was? What's like the good reason, right? The good reason. No, why do you think the state would, if you asked the state in court, why did you enact this law saying that you needed a store in the state to sell insurance? What do you think the good reason they would tell you is? From what? Good. You're almost there. You're really close. What are they protecting people from if someone from out of state selling insurance? Fraud, exactly. If you ask the state, say, we have this law to prevent fraud, right? We want to make sure that if people in our state want to buy insurance, that there's someone that they can go talk to, that's not some foreign business that will commit fraud. Now, this law can be justified on two possible grounds, right? On the one hand, I think Pamela said correctly, the real reason they did this was to prevent out-of-state businesses from taking away local customers, right? There's not much of a, argument. I think Pamela's right in the right track. But the good reason is that, well, we want to protect people from fraud. So we have these two possible rationales, right? On the one hand, it's to protect local businesses. On the other hand, it's protect fraud. Joseph, how would you weigh these two costs? Do you think that this is a reasonable way of protecting consumers in Louisiana? Is it reasonable? Why do you think it's reasonable? Why do you think the fraud rationale is reasonable?
It's going to be difficult to find someone. If they're not in the state in your locality.
Yeah. So do you think it's reasonable that the state conclude you want a local store presence if they want to sell insurance? Okay. Lee, defend the other side, right? Do you think that reason is reasonable or a sham? Say it's a sham.
I believe it's a sham.
Tell me why.
It's sham.
Tell me why it's a sham reason.
It's a sham because more than likely those insurance companies are contributing to some certain legislators' campaign funds. But that being aside, you want out-of-state business to ensure that businesses are being competitive for the people. And you want
Good.
our state businesses in Louisiana to go out-of-state too and compete against other businesses.
Okay, so you said two things that are probably true. So first, you said the local insurance company is probably lobbying for this legislation. Yeah. Who do you think pushes for these laws preventing you from buying out of state? The industry, right? The insurance industry, right? The insurance industry goes about and seeks laws that benefit their own common good. And the second thing you said is Louisiana are any better off, right? Maybe our Louisiana people are better off taking at the cheapest rate or the best policy. Why limit them to one state when they go to all 50? So here we have, Joseph and Lee, a reasonable policy debate where Lee makes some points maybe a little bit more cynical, and Joseph makes other points a little bit more deferential to the state, right? We can always have these sorts of arguments back and forth between two people of whether a law is reasonable or not. But the question, Ansel, you're up next, perfect, right? But the question is who gets to make this decision? The elected branch that enacted this law, notwithstanding these sham reasons, or the Supreme Court?
And to me, this is the precise question that we were talking about before. This questions like this, I think, should come to the people, right? And so if the Supreme Court is stepping into it, they should only do so in sort of very narrow ways because you're taking away from the people.
Did the people of Louisiana want this law?
In theory, they have a representative.
Ah,
right?
okay,
They're
good,
representatives. They elect representatives to a house.
Good.
That house represents their interest in
Yeah.
theory. So speaking through their constitutionally elected representatives, they do.
Good. All right, so here's the deal, right? Odds are the people of Louisiana had absolutely no idea what this law even meant, right? Most people pay no attention to any of the laws. People are rationally ignorant. They don't have time for this stuff, right? But their representatives did, and they enacted this. Maybe they were all being bribed off by the insurance industry. We don't know what's going on in Baton Rouge, right? We have no idea. But the people, effectively through the representatives, decided this. And then your court step in, and this is what the court did in Allegheny, and they said effectively that this law is unconstitutional, that this violated the liberty of contract of people. If the people of Louisiana want to go ahead and buy insurance from out of state, then you can't restrict their liberty of contract. So in this case, in many respects, the court stepped in and said, we're going to decide not the elected branches of, of Louisiana. They said that this is a law of pure protectionism. It's meant to protect local businesses, and this is not a legitimate interest of the state. This reason about protecting fraud, sham, right? The court said it's a sham, all of it. It's a sham, wow, right? It's a sham. We're not going to buy this sort of rationale. So this little discussion from between Joseph and Lee, I think, summarizes quite well the competing thoughts. Even if we can decide that indeed the rationale is a sham, and in some cases I'll give you later, the rationales are absolutely a sham. There's no conceivable rationale of why the government would do this for good interest. Do we want the courts intervening? And whatever you answer that question for today, consider also your answer for the question of birth control, abortion, sodomy, run down the list. Because if the elected branches want to criminalize all the above, our courts there decide that those are no more important rights. And this is one of the inherent tensions of substantive due process. Because it's great when you're on the winning side, but when you're losing side, it's like, wait a minute, I voted for that. He's taking this away from me, right? Okay. All right, so let's move on to, any questions about the Lochner? Okay, let's move to Lochner. I will start off by saying that there are probably maybe 2 or 3 classrooms in the country that will be taught Lochner what you're about to be taught. So I preface this because if you ask virtually any other law professor, except for if you mean a couple others, in the country about Lochner, they will say that this is the absolute worst case of the 20th century. That it ranks up there with Korematsu It ranks up there with Plessy. It ranks up there with Dred Scott. This is an action that and I think the book says something like, this is the wrong way of interpreting the Constitution. I think the book editorialized a little bit too much there, but I'll let it slide. Okay. Why, Blackman? Why, Josh, are you saying this isn't that big of a deal? Well, let's actually walk through the case very methodically, and I think maybe you'll see where I'm coming from. So first of all, I have a lot of pictures of the Lochner Bakery. The Lochner Bakery. This is actually Joseph Lochner, and you can see him here. This is a bakery in upstate New York. Picture of his bakery. The read I gave you, it's called Rehabilitating Lochner by David Bernstein. David was my ConLaw professor. Unless you have any doubts, I got an A- in his class, so there's still hope for everyone. I rub that in his face every time I see him now. We're friends now. So actually, the cover of his book, it's actually Justice Rufus Peckham knocking out Justice Holmes. And you see the Peckham banner here and the Holmes banner flailing. And there in the background is Joseph Lochner in his baking costume. And if you ever come to my office, which I hope you all do, I have hanging on the wall right behind me an advertisement for Lochner's Home Bakery. I discovered this. It was actually, I made calls to the Oneida, which county was it? Yeah, the Oneida County, New York Historical Society. I said, do you ever think about Lochner? And they sent me this Xerox of a, there were no phone books, but it was effectively a listing of addresses. And it says, Joseph Lochner, Lochner's is one of the oldest, most reliable bakeries in central New York. We pride. If you look here, there's like a little girl standing outside the sweet shop. So it's kind of a very cool picture. All right, so let's go through the facts of Lochner that the book discusses, and I'll give you what actually happened, because the book doesn't. Oh, did you just leave? I was going to call on her. Where'd she go? She was right there. I'll come back to her. So Lindsay, you can yell at her for dumping the fact one on you. But I turned away to nod. She knew. I had one student a couple years ago. She'd always get up when she was next in line. I always come back. So, all right, Lindsay, what were the facts in Lochner versus City of New York, please?
Okay, so New York enacted a law that prohibited bakers from working over 60 hours a week.
That's right.
And there was a baker, I guess, that had already done that. He was cited on the second occasion and fined or something like that for his overworking.
Welcome back, Ariel.
And
You're next.
he brought suit basically saying that it was illegal for them to regulate the hours. It had to do with the argument was that he had a freedom of the contract. And they were infringing.
Okay, very good, Lindsay. Thanks for pinch hitting, right? Okay. So those are the facts, right, of the case. Not too much in depth, right? You had a baker that wants his workers to go more than 60 hours a week. That breaks down to 10 hours a day. No one worked on Sunday back then. And, you know, when you first look at these cases, like, wow, you know, this boss was a jerk, right? He wanted his workers to, you know, be slave driven, right? To work 10 hours a day. This class in particular, does anyone work less than 10 hours a day in this room? Of course not, right? None of us do. So, well, maybe some do, but you keep your hands down. Most of us as evening students will work more than 10 hours a day because you have to. This reading, my reading alone puts you over at least 12 hours. So, the facts of the case are much more interesting. Why do you think, go back to Ariel, why do you think, take a guess, that New York would pass a law that limits the number of hours that bakeries can work? And I want you to build up the example I had with Lee a minute ago and Pamela, right? Why do you think that New York would pass a law that limited the number of hours that bakers can work? Give me the cynical reason first.
They don't want to pay for them to work more than more than 60 hours.
Aaron, let me ask you a question. Who do you think would support the law, cynically? Who supports a law that limits bakers to 60 hours a week or less? Who do you think would support that law? Take a look. Joseph Lochner there. He was an immigrant. I can't remember where he's from. He was an immigrant, pretty poor, had a couple guys working in his shop, trying to make ends meet. He needed his guys to work more than 60 hours, right? They could not keep up with the demand. Who do you think would be comfortable limiting bakers to 60 hours a week or less? Who? Tell me right again. Yeah, big businesses. Okay? And think of it like this, right? I'll give you a very good contemporary example. The minimum wage for fast food, right? Which fast food restaurant do you think will be most able to absorb the cost of minimum wage increase? McDonald's, Burger King, right? What if you're a small fast food place that's just starting out, you only have a few franchises? That sort of change will put you out of business. McDonald's doesn't care, that's more business for me, right? So in every single situation where there's a labor law that increases the cost of labor, the party most able to absorb that cost are the biggest businesses. So, Ariel, I'll go back to you. In this environment, so who do you think wanted this law in effect? That said you can only work 60 hours a week in bakeries. The law only affects bakeries. Which groups do you think wanted a law limiting 60 hours to bakeries? Based on what you just said. Which kinds of bakeries? Exactly. Okay. So effectively, who supported this law but the bakery unions? Right? The big entrenched bakeries supported these laws as a way to put their competition out of business. Make no mistake. These laws were designed to put competitors out of business. Poor Joseph Lochner had to basically work 18 hours a day to keep up with his bills. But if you had a more established bakery, then instead of hiring 3 people to work 10 hours, they can hire more people to work 8-hour shifts. Oh, right? Does it make a difference with bigger bakery where they have 5 employees or 3? No, it's just the same number of hours. Lochner only has 3 guys helping him. There's also a distinctly racial element here. These laws are very anti-immigrant. Lochner was a poor immigrant baker trying to make a living in this new country. Okay? He had to work 20 hours a day to actually make ends meet. The more entrenched bakers could hire more people to fill the billet. Andrew?
I was just wondering, I read that most of the multi-bakeries were German owned.
Yeah.
So the immigrants were catering to different demographics, like Jewish immigrants.
Oh yeah, I'll learn my language.
So why would they want to stop that if they weren't going out?
They want to dominate. They want to put them out of business. This law was designed, and this is Lee's cynical, right? I'll give you a second. But this law was passed for the express purpose of putting small bakers out of business.
Do you think it was maybe to protect the employees?
So I asked Ariel and by extension Lindsay, right? What is the cynical reason for this law, right? The cynical reason is to put small bakers out of business. Sandra, what's the charitable reason, the good reason why this law is enacted? Okay, so yeah.
I mean, think of like the jungle, the Chicago stockyards. At that time, and people being overworked and bad working conditions, maybe bakeries had a bad stigma then for the same thing.
It's mostly for the people who actually not the workers. Tend to care about the workers more than what they're doing.
Okay, good. So we have here, I think, 2 cases. Same way that Joseph and Lee had this debate, right? We have a similar debate here, right? On the cynical side, and this is the true history of the bill, and just to give you a little of the background, you have a law that's designed to put the smaller bakers out of business. But there is indeed a beneficial angle to this as well. And the beneficial angle is if the workers work less, they're less likely to have unsanitary conditions, make healthier bread that people are going to eat. Okay? So I want to introduce a concept to you that I think I mentioned before. discussed the Baptists and the bootleggers. This is a concept of economics I think explains this quite well. So take something like prohibition, right? The elimination of alcohol. Who favors prohibition? Well, you have two groups. On the one hand, you have the Baptists. These are the people who oppose that morality. They want to help the people. They want to save the children from the wicked, the wicked alcohol and the liquor, all this stuff. Who else favors prohibition? The bootleggers. And why the bootleggers favor prohibition? Because it jacks up their rates, right? It puts everyone else out of business except for those willing to break the law to sell the alcohol, which is the major event. So in this case, the Lochner case, right, I think you have both the Baptist and bootlegger coalition. You have the Baptists, right, the Upton Sinclair, the Jungle, those who want to help improve working conditions, like you said, right? But you also have the bootlegger. And the bootleggers are the other German bakers who want to put out of business the small competition. Which of these is predominant, right? Which of these is predominant, Maria? Which plays a bigger role in this law? The Baptists who want to help people, or the bootleggers want to put their competition on business? Which is a bigger coalition in this case? What do you think? So in that case, what do you think the answer to that question is? Which interest predominated to pass this law?
In this case,
Yeah, the bakers, right? So from an economic analysis, right? Let me give you another term. Anyone ever see this phrase, rent seeking? Anyone ever see this phrase, rent seeking, in your economics classes? There's a concept in economics called rent seeking. The idea is a rent is something good that government can give out. Rent is not just what you pay for your apartment. Rent is some sort of favor or benefit the government can bestow. And rent seeking is when the people use the government by lobbying or bribing, whatever, to get benefits. So this idea of trying to shut down your competitors to the government is a good example of rent seeking. And from an economic perspective, this law is probably pretty clearly predominantly about rent seeking. It's predominantly about shutting down your competitors to help yourself. How do we know, Adriana, how do we know this law wasn't really about sanitation? How do we know? Take a guess if you're not sure. What was the only thing this law did? Did it say that you had to have certain health conditions, you have to wash your hands, or anything else? Did it say you have to clean your ovens? What did it say? Yeah. Okay, so here's the issue, right? If this indeed was meant to protect health and safety, it's doing a very awful job at that. All it does is limit hours. It didn't even pretend to restrict sanitation conditions. Right? So this is all good from an economic perspective, right? But we come back to Angelo's question we opened the class with, right? Should judges be in this sort of business? Should judges be in the business of deciding, you know what, New York, you passed this corrupt law, your rationalization's a sham. We know what's going on here. You're trying to protect the big businesses. Not going to work. If Lochner wants to make this contract with his employees, then they can do so. Should courts be in this sort of business? Now, the reason why Lochner is so infuriating to many is to answer the question, yes. It says that there's a distinct role for the courts in weighing the reasonableness of a statute between the Baptist interest and the bootlegger interest. It's effectively saying, we don't buy your explanation. All this gibberish about safety, no, not happening, because you have nothing about safety. It's all about hours.
Angelo correctly said, you know, people could just vote out the legislation, but if the people are in a position that they're a minority or that they don't have the voting power, then under that thought, they will always be treated, deprived of their
So your question's a good one. I think Sandra said a minute ago, or someone else, which group pushed this law forward? And I think the special interest answer is easy. It's the bakers, right? The unionized bakers who had money to pass for this law. What about the small immigrant bakers? they're able to get these sorts of laws repealed. Lee?
They gotta unionize.
Well, if they get unionized, they want the hour laws also. The hour laws benefit the unions because they have to go through them for work. If you limit hours, you need more workers, and that's where the union comes in. But the shorter answer is, can these small groups like immigrant bakers try to get this law repealed? You're shaking your head no.
Yeah.
Right? So what you're effectively arguing is that the democratic process doesn't work here. Right? The democratic process doesn't work. Right? That's an audacious argument. And the argument, the follow-up, I'll get you in a second, Lindsay, is that because the democratic process isn't working, the courts intervene to reinforce the representation of the immigrant bakers. Lindsay?
But why also could the argument not be that it's just the judicial system checking the legislature or the executive branch?
On what basis is the check happening? What gives the courts a license to do this checking?
Well, if the judicial branch is to interpret the law, can they are they supposed to interpret what it was intended for?
And what law are they interpreting?
Well, in this particular situation, it would be the 50 hours.
Well, no, that's a statute that we have an issue. What law gives them the license to validate that statute?
Oh.
Well, answer. What,
So we're just going back to the Constitution.
what provision of the Constitution are we talking about?
Well, it's more than just the Fourteenth Amendment.
Well, what else could it be? It's a state law. We're not talking about a federal law. It's a state law. So effectively, the courts are reading Section 1 of the 14th Amendment, due process clause, as a license to invalidate the state labor law. And even though the 14th Amendment has liberty, the courts also decide for themselves what that liberty is and how broad it is. Darryl?
The democratic process would be like the prohibitionists and those, but they could bring up kind of a groundswell and point it out to people. So the court shouldn't be short-circuiting that process from the get-go.
So the court should not be intervening here.
Not at this time.
What do you mean not this time?
Because the people could bring up groundswell, the grassroots and say, hey,
Couldn't the statute be repealed? Couldn't New York repeal the statute? Was such a bad idea?
if they got enough.
Couldn't Joseph Lochner, instead of going to the courts, use other means?
Right, that's what I'm saying. Get the groundswell, get people, bring it to people's attention, and then maybe, get it, vote them out of office, vote their people in, let the process work itself out.
Elizabeth? Yeah, so democracy takes a while, doesn't it? But a court case, man, that's quick. Is it bad that democracy takes a long time, Elizabeth? Deliberation takes time. Yeah, so Sam, Yvette, did you hand up?
It just seemed like a lot of trouble to go through for such small bakeries compared to the big bakeries. You just think that there'd be room for everybody.
Yeah, the courts are always easier. I mean, this is why law students, all you study is courts. All you study is courts. You never study the legislative process at any point in your law school career, which is damning. So if you give a person a hammer, they see everything as a nail. If you have a lawsuit, a problem, they see every single solution as a lawsuit, right? Every single problem you see, oh man, we got to sue, right? This is not fair. We got to go to court. You can pass laws outside of a lawsuit. You can go to the legislature and you can lobby, but I think both of you raised fair points. This is a cumbersome process, and it's unlikely that the small immigrant baker can overcome the institutional inertia of the entrenched. So I hand some over there. Yeah.
I was going to say, I was reading the bakeries, it took them 6 hours because they had large amounts of dough.
Yeah.
It took 6 hours for the dough to harden, so they could have known that it's going to take the Jewish bakeries longer to actually produce the bread.
There's a lot of racism here, and I don't say that lightly, but xenophobia and racism ain't new. And there was a serious movement to exclude the immigrant bakers, the immigrant furriers, all the immigrant professions. They were trying to exclude them. And if you're in a bigger business with more sophisticated equipment, I'll give you other ones, right? A number of laws were passed, one case called J. Burns, limiting the weight of bread. That a loaf of bread had to be a very specific weight. Why? Well, if you have sophisticated equipment that can chop the dough at very even increments, right? And specific ovens that can apply equal amounts of heat, when you bake bread, it kind of expands or not. You can get the weight in a certain range. But if you're just, baking in your basement, just chopping up bread and whatever, braiding it, whatever, you can't control it. So a lot of these laws are meant at punishing the small bakers and making it impossible to stay in business. Daryl?
The microbreweries, those are just now being legal for every, you couldn't brew beer in your home. It was crazy.
Yeah, and these are also laws based on protectionism of the established brewers. I can't say the word brewers. Okay? Yeah, Michelle?
Okay, so another route would be then to limit the amount of money you can give to your legislators. So how do
Whoa, what was the First Amendment?
I was just saying, how does the court do that? I mean, we've had our federal government do that through some of the federal statutes of how much money, an individual can give a campaign and all that. So how do the courts view that where voters have said, okay, we can't compete with the big companies out there. And a lot of legislators have responded and enacted,
Well, I mean, that's really a critique of the democratic process itself that's unresponsive to influencing lobbying, isn't it?
Well, I think it's trying to balance it for the little guy out there who can't wait till possibility of having enough numbers to repeal a law.
The issue of the court.
I know, but what I'm trying to say is, of course, then there's the route of people saying, well, you're affecting my First Amendment of being able to give money to whoever I want and how much I want. So my question is, how does the court view that in balancing what had occurred in Lochner? Which is where they helped.
Ask me after class. It's a really complicated answer.
All right.
Ask me after class. There's an answer, but it's way far afield. All right, so where were we? Let's go back and actually walk through the case now. So, Earl, how does the court define this right of contract that we discussed in this case? And whose right is at issue in this case? Who are the employees making a contract with? Okay, that's why it's Lochner v. New York, right? Lochner was the head of the bakery. The argument goes like this. If Joseph Lochner wants to make a contract with his employees for 80 hours a week, that the state does not have an interest of stepping in and blocking him from doing so, that they want to make a contract on, arm's length contract, that they can do so. Okay? Kara, what's the argument against this notion, this sort of arm's length equal bargaining power contract? What's the argument against that? Is this in fact an equal arm's length contract between the two parties? Here, let me show you a picture. Maybe this will make it clear. Here, those are the guys working in the bakery. Do you think there's an equal arm's length contract between these guys and Lochner?
I don't see why there wouldn't be.
Oh, I agree. Well, explain why there might be. Give me an argument why there might be.
Why it might be equal.
Yeah. You're agreeing with the majority, but why might there not be?
Why might it not be equal?
Yeah.
Well, they probably didn't have enough money to open a bakery.
Okay.
Lochner probably did, and so it's probably not equal since they don't have much claim anywhere else to go to make a lot of money.
Okay. So the argument basically boils down to this. Is there equal bargaining power here? Are these parties on an equal basis, right? Is someone who owns a bakery actually able to negotiate fairly with some, immigrant fresh off the boat who wants to bake some bread? And the state here, New York, stepped in and says, you know what? We don't think it's equal, right? We don't think it's fair that these poor workers are being exploited and being made to work so many hours per week. We want to limit the number of hours they're working. Debbie, were these workers being exploited?
You could argue that. You could also argue that they were happy to have to work.
Do you think these workers who literally came right off the boat wanted to work more than 60 hours? Why?
I think they wanted to make money.
For what purpose?
Well, they just got here. They had nothing. They were trying to establish themselves. The reason they came in many cases was for the opportunity to work.
Imagine that, right? So this claim of exploitation, right? If you take off your 2015 glasses and you put on 1905 glasses for a minute, if you were a poor immigrant who came here and you're trying to save up enough money to send for your wife and kids to join you, right? You're going to work as many hours as your bones allow. That's, I mean, the plight of immigrants is the first generation who works insane hours, and under conditions that other people may wince at. But this law eliminates that potential because the law presumes that these are people, who can't possibly want to work that many hours. Now, note, this is not a wage law. This is not saying you have to pay them a certain wage. It's simply saying that you cannot work. It's illegal to work more than 10 hours. Now, could the same employee go across the street and work another 10-hour shift across the street? Yes. You can't work for the same employer for more than 10 hours. Seem reasonable? Why not?
First of all, if they really were writing a lot of concerned about the immigrants, regulate the wages so you never pay a fair wage, don't just regulate the amount.
Good point. Good point. But Ingrid, let me ask you this question. If the state imposed a minimum wage, what do you think Lochner would have to do? By the way, so which types of bakers among these groups love minimum wages? Why?
Because they're able to go back to your example of McDonald's, they can afford it.
They can absorb it. So unions love minimum wage laws because if you have the minimum wage, then the unions have to get more because they're given training and other things, right? So if they impose a minimum wage law, these bakers would have to work under the table because they couldn't afford that many hours. Lochner couldn't afford to pay them 10 hours, pay them less. So there's no panacea. I'm not trying to make this a lesson in economics, right? But there's really no panacea because invariably people want to work that many hours, they'll find a way to work. But this law, in fact, makes it illegal and will fine Joseph Lochner. Okay? So any questions in this discussion so far? So the court goes on to discuss the police power of the state. Kathy, what is this police power of the state? You got one of them? Perfect. Yes, perfect. I just did some property an hour ago. Yeah. The police power is what gives the states the powers to enact laws. And the history of this is actually interesting. So when there were colonies, right, who had the police power belonged to the King of England. And what happened in 1776 when the states declared their independence, that police power devolved to the states. And the states had this massive sovereignty, this massive power to enact various laws. But when they ratified the Constitution, the states gave up some of that authority. So, for example, the power to regulate commerce, the power to declare war, the states gave up this authority and gave it to the central government. But that wasn't the only relegation of power. When the states ratified the 14th Amendment, they gave up other parts of their police power because they can no longer pass laws that violate equal protection. They can no longer pass laws that deny due process. By ratifying the 14th Amendment, the states gave up their authority and gave the courts a power to check that authority. So here we have the police power which can regulate the health, safety, welfare, and morals of the people. But as we discussed, the court is skeptical, saying, listen, this law isn't about safety. Give me a break. There's nothing to do with sanitation conditions, nothing to do about wages. All it says is you can't work more than 10 hours a week at a single bakery. You work 10 hours somewhere else also. This law is merely meant to punish small bakeries. And that's what the court's analysis is based on. And they identify that the police power must have limits. They are not substituting the judgment of the court for that of the legislature, but they do say the courts have a role to inquire if this law is within the police power of the state. Okay? The actual analysis is fairly straightforward. They say it may be dismissed in a few words because this law is so obviously meant to protect the big bakers. They write, quote, "There is no reasonable ground for interfering with the liberty of person or the right of free contract by determining the number of hours of labor." Okay? There is no contention that bakers are not equal in intelligence and capacity to mend other trades. In other words, They don't need interference from the state. Bakers can decide for themselves the appropriate wages, the appropriate hours. Okay? This is not a case that involves a dangerous profession. This is a case involving coal mines or a case involving, people working, in a field somewhere. Maybe, but they are working here in a bakery. It's a safe environment. And, quote, merely limiting hours does not impact the health of consumers. Does a person working less make the bread more safe? Well, they say no. I think Brian said, yeah, if you work more hours, more likely to drop things on the floor. This argument is probably a little bit off, but we're, again, viewing this through 2015 lenses where everything's sanitary, not in 1905 where sanitation didn't really exist yet. The court holds that clean and wholesome bread does not depend on whether a baker works 10 hours a day. It makes no difference. Okay. Any questions so far? Marco?
I wonder if the law or the city of New York passed the same law, but instead of making it so narrow to one industry, they just said across the board, no one's allowed to work more than 8 hours.
Well, those laws came much later, right? And by the time those laws came around, the courts no longer were following this doctrine. Yes, that's true. The employer will be fined if he employed someone more than 60 hours a week. Who's himself? And this is the point the majority raises. They say, how many professions are there where people are expected to work more than 60 hours? Lawyers, for example, right? Bankers. And the court basically says, if we let this one go, then every single profession can be limited in the number of hours they can work. So a law firm himself can work as many hours as he wants. But his employees could not, and he'll be fined if you let them work that many hours. All right. Yes.
Is there any argument that the state didn't argue or New York didn't argue since it was a state law that the state of New York knows the best how to take care of its citizens?
Well, that's exactly what New York argued. They said this is our police power. We can decide for ourselves.
And we invested protecting the liberties of our state citizens.
Oh. So here comes the issue, right? On the one hand, New York can say, we are protecting our workers from being exploited. We're protecting our workers from being exploited. On the other hand, you have Lochner saying, wait a minute, these guys want to work these hours. We're not exploiting them. We're actually giving them a long career. Who gets to make that decision? Who's right and wrong? The Lochner majority says we will decide, and we think that this law is actually hurting people, not helping them. That this entire exploitation thing is a farce. That you're not protecting them from anything. They're smart people, and they can decide for themselves what they want. Steve?
Well, I mean, I think I'm thinking this correctly. To me, the majority's opinion was more, if we talked about strict scrutiny.
I was going to get to scrutiny in a minute. Oh, you took my next point. Go for it.
Like burden of proof.
Yeah. Yeah. So, I mean, that was my next bullet. You're right on target, Steve. So, we talk in terms of scrutiny, right? We talk in terms of a means ends fit. Okay. So, where was I up to? Pam, what is the end the government's trying to achieve here in this case? If you ask them in court, right? What's the end that the government's trying to achieve here?
To limit the hours that.
No, but why? What's the goal? What are they trying to achieve? Why did New York pass this law if you ask them in court?
The quality of life.
They're trying to protect workers, right? They're trying to protect workers. And I don't know, and sanitation, whatever, right? Pam, what are the means used to get to that goal? How do they go about doing it?
Enacting a regulation on the number of hours.
Okay, 60 hours, right? So we asked the question, what's the fit? How close is the fit between limiting workers to 60 hours in one bakery to improving the conditions of workers?
It's not very close, especially considering they could go work at a different bakery.
Right. So, Steve, to your point, there's not a very close fit between the two. when the court's saying that it's not reasonable, what they're basically saying is, look, there's not a good enough connection between one and the other. Okay? The word strict scrutiny hadn't been invented yet, right? We're still, 40 years away from strict scrutiny. But in terms of how the court's assessing it, it sounds an awful lot like strict scrutiny, doesn't it, Steve? Who has the burden? Bingo. The state has the burden, not the individual, the state. And in constitutional litigation, the party with the burden usually loses, right? If you have to prove that your action is a tight fit, you're going to lose. By placing the burden on the state, the court's effectively making it New York's job to have very tight fit. New York must only pass laws that are narrowly tailored to serve the interests they're trying to achieve. And this, the court says they cannot do in this case. Questions on that? I'm not done with the case yet. I told with this case for a long time. Yeah, Michelle, go.
All right, so Steve brought up something that wasn't occurring yet in the courts regarding scrutiny, and I'm gonna go ahead and do this. Where would this economic or liberty fall under being a fundamental or a non-fundamental?
So the phrase fundamental rights hasn't been invented yet. We didn't get to fundamental rights until footnote 4 of Caroline Prada, my favorite footnote, which I'll get to in about 20 minutes. Right? That phrase didn't exist yet. But the court treated this liberty interest as one of the utmost importance. One of such importance that the state law enacted by the democratic process fell because of it. Steve?
Where I saw this was they're saying it's supposed to be 2 hours of states that have the right of liberty of person and freedom of contract. The need freedom of contract is one of the significant rights.
So again, this is a point where, again, what I'm telling you is probably the vast minority of law professors. So I preface it that way. But there's a pretty strong historical argument that the right of contract was understood at the time of the framing of the 14th Amendment to be among the fundamental rights. There's a pretty good argument there. Every law professor will say you're insane, but whatever, I'll say my opinion on that one. Assuming I'm wrong, and let's just assume I'm wrong for a minute, that means the court made this right up of whole cloth. And they're indeed using some sort of economic theory that's not consistent with the Constitution. And this is effectively Holmes's point in dissent, which I'm not a fan of, but we'll get to it in a minute. Okay? Other questions? I'm not done with this case, don't worry. Okay. The court also dismisses any sort of health concerns. They listen, this is not a dangerous profession. It's not like coal miners. And also, this has nothing to do with the actual sanitation of the bread. If they worry about dirty bread, pass law governing how cleanliness standards must be maintained. Okay. The court also references trends. Towards the end, they say, listen, there are all these laws coming about in what may be dubbed the progressive era. The court says, it is impossible for us to shut our eyes to the fact that many of the laws passed of this character, while passed under what is claimed to be the police power for the purpose of protecting public health or welfare, are in reality passed for other motives. Let's say it again. We cannot shut our eyes to the fact that many of these laws passed under the guise of the police power are indeed passed for other motives. This is a Baptist and bootlegger example I gave you before. They come to court saying, oh my God, public health, but really what's going on is illicit purposes. Peckham writes, we are justified in saying so when from the character of the law and the subject upon which it legislates, it is apparent, here's a key part, that public health and welfare bears but the most remote relationship to the law. That the public health bears but the remote relationship to the law. This is the question of fit. There's such a weak fit between public health and what they're trying to achieve. Okay. At this point, the court steps in to invalidate the law. There is, quote, no direct relation and, quote, no substantial effect on the health of employees. This is not a health law. The real object of this law, the court says, was to regulate the hours of labor in a private business, not dangerous to anyone. All this is a regulation of hours for the sake of regulating hours. And this, the court finds, violates the Constitution. Okay. Questions in the majority opinion? Questions, Justice Peckham? Okay, this majority opinion was scandalous at the time. All progressives from Teddy Roosevelt on down clamored against this because they saw the courts as a conservative institution that would halt the spread of progressive laws. Even as progressive legislatures were spreading throughout the state, enacting these sorts of labor laws, the courts were viewed as the biggest obstacle of stopping this. Now, most people only think of the dissent of Justice Holmes when they read Lochner. It's the most famous dissent by the 20th century. But I want you to focus on the dissent of Justice Harlan, which is actually the opinion I'm probably closest to, also because Harlan has a lot of good things to say. So, Marco, back up top. Justice Harlan, by the way, has 3 justices in his dissent. Holmes only dissented by himself. No one joined him. So this is a lead dissent. Marco, what was Justice Harlan's opinion about?
Harlan went middle of the road where Holmes was on the complete opposite side, saying that an economic decision and the states know what's best for the people. Harlan came in the middle of the road saying that the states absolutely have the ability to police their people, police power, but that indeed this case did have some health and safety issues as far as workers go.
Good. So, Mark, let me ask you this question. Did Harlan believe that the 14th Amendment protected a right to contract? Yes. And this is the point that most people don't really accept. This is why I think the book's claims are a little bit overwrought. 8 of the 9 justices in this case agreed that the Constitution protects a right to liberty of contract. That's why I think the book stretches a little bit too much. Only Holmes disagreed. So Harlan says there is this right to economic liberty. But Marco, does it trump the state's interest in this case? Okay. And the important discussion is why. I think Marco said it very clearly, right? The state here has some good reasons, right? Harlan says people in long working conditions may become tired, and if they're tired, maybe they won't have enough time to promote sanitation. Okay? But more importantly than this sort of balancing, he rejects this means and fit. He doesn't look for a tight fit. Elizabeth, what is the test that Harlan puts forward to discuss when a court should step in to invalidate an act of the legislature? Exactly right. He says like this: the court should never step in to invalidate a law unless it's, quote, beyond question, plainly and palpably in excess of legislative power. Quote, beyond question, plainly and palpably in excess of legislative power. Elizabeth, what does that mean? Elizabeth, under Harlan's interpretation, what happens if there's a statute that's a close call? There's some good reasons behind it. There's some bad reasons behind it. What should the court do in that situation? Why? Why should they stay out of it? Yeah, okay, very good. This is what's often called a model of judicial restraint. And Harlan articulates it, that if there's some way of reading the statute consistent with the Constitution, the court should stay out and so read it. So if we have a law that's passed, and yeah, maybe it was based on cronyism to protect the unions, but there's some good stuff that maybe will make the bread taste healthier and they'll protect workers from being exploited. If there's some way of upholding it, the court should. Harlan says the only way we invalidate a law is if there's no conceivable way. There's no possible way this law could be constitutional. Okay? By the way, Harlan actually means this. In a case later, a year or two later, he actually invalidates other laws like this. So Harlan actually says, here, this law is good enough that we're not going to get involved. Okay? We do not need this sort of narrow tailoring or this fit. Okay? Yes, ma'am.
Would Harlan ever make the decision to rewrite a law to save it?
Would he pull over John Roberts? I don't know. I don't think he ever did.
Okay.
Rewriting law is a different story. Well, we'll get to Obamacare and Lochner in a minute, though. Funny that you mentioned that. I'll play it now. I'll never forget. So actually, I think Michael emailed me this tonight. I see this. C-SPAN has tonight at 9 p.m. A special on Lochner. So I know as soon as you get home from class tonight at 9 p.m., you're going to turn on your let's see if this works. It's only plugged in. Okay, let's see if this works. So in 2012, as the Obamacare decision was being argued, President Obama, former constitutional law professor, made these remarks. No.
Supreme Court to overturn law.
Yep.
President, you said yesterday that it would be unprecedented for a Supreme Court to overturn laws passed by elected Congress.
So the question was, and I'm not just plugging it, but Obama had said it'll be unprecedented for the Supreme Court to overturn the. Okay, listen what he says.
If that is exactly what the court's done during its entire existence, if the court were to overturn individual mandate, what would you do or propose to do for the 30 million people who wouldn't have health care after that ruling?
Well, first of all, let me be very specific. We have not seen a court overturn a law that was passed by Congress on a economic issue like healthcare that I think most people would clearly consider commerce. A law like that has not been overturned at least since Lochner, right? So we're going back to the 30s, pre-New Deal. And the point I was making is that.
Okay, that point doesn't matter. So, read the book. I got the rest of the speech in there, right? So, I only mentioned it because Michelle brought up Obamacare, but in the mind of law students, Lochner's view is the most evil thing ever, right? And indeed, the president compared the Supreme Court invalidating Obamacare to the Lochner decision. The issue is entirely separate because Lochner involved a challenge under the Due Process Clause, and Obamacare was under the Commerce Clause of the federal government. The issues aren't even together. But Lochner's view is an epithet, right? Instead of like cursing, it's like F you, right? You say Lochner. It's like this vampire that creeps around. You have to, curse people who even invoke it. Let's go back to Harlan for a minute, right? Harlan says, quote, "We will not presume that New York acted in bad faith. We will not presume that New York had acted in bad faith. We will not presume they didn't act for the common good." This is the exact opposite of the majority. The majority said, listen, you guys are acting in bad faith. This is a sham. Or would you say, Lee Kroc, what word did you use? Sham, right? Yeah. Yeah, it's a sham, right? The dissent's like, listen, why are we going to assume the democratic process of New York is making sham laws? Like, who are we to judge? Who are we to say that the elected process of New York is making all these bad laws? Okay. Harlan closes by saying a decision voiding this law would have, quote, far-reaching and mischievous character. Far-reaching and mischievous character, it would, quote, seriously cripple the inherent power of the state. So Harlan's basically saying, like, look, the progressive era is growing up. We're going to have lots of these sorts of laws. If the court steps in to invalidate this is going to have a serious crimp on the progressive state and the ability of states to regulate welfare. Because now not only must states have to worry about the political process and actually get a law through, but they have to worry about the court stepping in years later and invalidating these laws. Okay, so Harlan's dissent is one, again, I think I probably fall closest to. He says, listen, there is this liberty of contract, but we should not be presuming states act in bad faith unless there's really good evidence that they are acting in bad faith. Okay, so let me give you a couple examples of laws that may trigger Harlan's dissent. So I think I mentioned this last class, but everyone know what eyebrow threading is? Okay, it's where you take these like little basically threads, you put it on a person's eyebrow, and you yank it out. I've never had it done. If any of you want to speak, well, you can vouch, but I've never had it done. Okay. Texas, our home state, passed a law, and the law said in order to be an eyebrow threader, you had to go through cosmetology training. Okay. Cosmetology training requires learning how to wash hair, how to cut hair, how to color hair, how to do all these things except for eyebrow threading. Okay? There was not a minute of training in the cosmetology program that anything to do with eyebrow threading. Not even a single second, right? Yet this was an expensive program. It take 2 years of your life to just pull, threads out of your eyebrow. Is there any possible justification for why this law exists? Shaking your head, yes. Oh God, you guys are learning. I'm so proud. Yeah, the reason why this law exists is to put potential competitors out of business, right? If you want to be an eyebrow threader, you have to go through all this training. And by the way, you need to work in a salon. The way you get trained by working in another salon. You pay money to other hairdressers so you can train with them, right? You go to hairdressing school. It's an entire cottage industry, right? But is there any that's the bootlegger interest, right? Is there any conceivable Baptist interest here? Is there any reason why the state may have this requirement that's actually for the benefit of the people? There's no training of how to thread eyebrows in the entire class. Not a single minute of how to do it cleanly. Steve?
From the state point of view, I would say that you're supporting their
Diversification of what?
They're working in a salon, so that gives them the ability to perform.
But all this person wants to do is thread eyebrows. They don't want to do any salon function. That's, the person. This is actually a Texas Supreme Court case called Patel versus Department of something or other. Yeah.
Well, even though sanitation isn't required in that, just in general, since it's part of the curriculum.
So couldn't the state have, like a 5-minute course on like washing your hands before you thread someone's eyebrows?
Or just general.
I mean,
just saying,
their
justification could be.
Yeah, those little hand sanitation goes. Okay, let's go. Yeah, Michael.
With the cosmetology schools, would it require the students to get financial aid or something like that? So we have money in something area causing a great deal of
Yeah, right. So let's put it this way, right? This law, this Texas law, doesn't have many good reasons for it. And to the extent that sanitation is concerned, give them a 5-minute class of washing your hand with warm water and soap, I think they'd be okay. The Supreme Court of Texas actually invalidated this law under the Texas Constitution's Due Process Clause. But there was a vigorous dissent by an alum of the school, Justice Guzman, among others, who said, no, this is Lochner. And, they just scream out Lochner as if it's some sort of vampire that we can't have judges second guessing, even though there's no reasonable reason to have this sort of law. Let me give you another example. The state of Kentucky, or the Commonwealth of Kentucky, passed a law saying that in order to sell caskets, which are effectively wooden boxes, you have to be a licensed mortician. You have to learn how to embalm a body, how to, handle corpses, how to transport dead bodies to sell wooden boxes, right? I was up to Steve. What's the reason why this law was passed? And if you ever dealt with the death in the family, you probably know the answer to this one pretty well. Protection of who? The funeral directors. These are some of the biggest, how do I say this nicely? I can't. I can't. I'm going to sue for libel, right? This industry is known for not being the most fair, especially in a time of grieving. They often charge very high prices. So what you have was, this happened in Louisiana also. You have a group of monks in Louisiana, right? St. Joseph Abbey. And these monks decided to sell caskets as a way to fund their monastery, right? And the state of Louisiana stepped in and said, oh, no, you can't do that. You can't sell those caskets because you're not morticians. These are monks. They're not going to be morticians. They're not interested in handling dead bodies. And what was the state's interest in doing this? Well, they said, well, it might lead to improper disposal of bodies. Well, you can dispose a body without even a bag. You can just throw it in the dirt, and that, the dirt, that's perfectly legal. And the Fifth Circuit actually stepped in, as did the Sixth Circuit in Kentucky, said these laws are unconstitutional. There's no conceivable basis on which to have these. Another one that I can mention, the state of Louisiana said to be a florist, you have to be licensed. And to be a licensed florist, you need to pass a test. And what is this test? You need to make floral arrangements, and other florists have to judge whether they're good or not. So effectively, the people who your competition are judging whether your flowers arrangements are pretty enough. Okay? What was the state's interest in protecting the floral industry? They said, we're worried about infected dirt. That people may cut themselves and infect the dirt and give these potted plants to people, and then the people may get infected from the dirt. Wow. The person would say, wow. Yeah. So basically, in that case, too, unfortunately, the court upheld this regulation, saying that this was a valid use of the police power. So, for the most part, even Justice Harlan's dissent hasn't won the day. The dissent that has won the day is actually by Justice Holmes. Any questions of those examples first? These are actually cases by a group called the Institute for Justice. And if you Google them, they're a public interest libertarian law firm. And they basically litigate these sorts of cases all across the country. And I'm a fan of theirs, so I'm in the tank. Yes, Steve? Oh, Institute for Justice, IJ. Yeah. Yeah, right. So the majority opinion probably approaches strict scrutiny. Harlan has some sort of rational basis. As long as the government has some good reason why this law should be upheld, it ought to be upheld. But if we're dealing with infected dirt, or monks selling caskets, or one of these other cases, or eyebrow threading, where the government can't have any good reason why they have this regime, then the law should fall. And I think that's more or less what Harlan falls down, which is what I usually tend to agree with. Yeah.
I guess I'm becoming a little bit confused with the federalist role versus progressive, because to me, in a situation like this, like in this case, when you have the Supreme Court stepping in on state rights, it's dangerous to. It seems like the progressive would want to back that, and the federalists would want to say, not really look to revive something like that, because it's a small line between doing that and doing something like Obamacare with the Supreme Court. It seems like they would want to keep the Supreme Court within due bounds.
So, Roy, the short answer to your question is that the 14th Amendment altered the federal and state balance. The 14th Amendment, the states gave up their police power. They can no longer pass laws that violate due process of law, and presumably the courts are the ones to police that. So absolutely, the 14th Amendment shifted the balance between the federal and state government. That's the short answer. I may have a longer answer, but no time for it. Is your hand up, Lindsay? Okay. Other questions? Yeah, Lee.
There's kind of a similar situation going on with Uber.
Oh, I'm so glad you mentioned that. So, I mean, the entire issue with Uber, if you know, it's a ride-sharing service. You have your smartphone, you call an Uber, and it comes pick you up, right? It's significantly cheaper than taxis. Why? Taxis have to go through serious regulations. Just as an example, I recently took an Uber to the airport. It's $40. I took an Uber home, it was $110. I'm sorry, I took a taxi home, it was $110. I'm getting reimbursed, don't worry. But it was midnight when I got home. It was a very late flight, and there were no Ubers around, so I had to take the taxi. Crazy about it. I think I had too much cologne on. It was gross. So it was bad. But the short answer is yes. The taxis want to keep out competitors. So the city says, oh, we need to have drivers have all these regulations and certifications and background checks, which makes it more expensive. But Uber's managed to operate in hundreds of cities with better cars, and you can actually rate them. And if they're a bad driver, you give them a bad rating, they get fired. Taxi drivers that smell bad, they stick around forever. This guy was, he had way too much cologne. He was like, "Do you want to close the window? The AC?" I'm like, "No, the window's good. Window's good." It's really bad. Mark, tell us about Justice Holmes's famous dissent. This is probably the most famous dissent of the 20th century. Build up. Let's go to it.
Well, he basically said that this case was kind of built up largely on economic theory.
Good.
And that that the Supreme Court before had decided, all sorts of cases where the state may have created laws that kind of interfered with this theory of contract before, and that it was something that they had the right to do.
Yeah. So Holmes basically said this is all mumble jumble. It's all made up, right? He said this entire case is decided upon an economic theory, which a large part of this country does not entertain. He says, if I were asked to study this further, I can make up my mind one way or the other. But there's nothing in my role as a judge which allows me to say that this role is correct, this role is not. He says there are lots of laws that infringe on liberty, and they control how people operate, and it is not for the courts to intervene. And perhaps the most famous sentence in this most famous dissent, he writes, quote, "The 14th Amendment does not enact Mr. Herbert Spencer's social statics. The 14th Amendment does not enact Mr. Herbert Spencer's social statics." Does anyone know who Herbert Spencer is? Anyone? Okay. Herbert Spencer was a famous philosopher or an economist in the 19th century who was a proponent of what was called social Darwinism. This is the belief that, much like Darwin said in evolution, survival of the fittest prevails, social Darwinists often said that in a society of industry and commerce, the strongest and smartest will prevail. His most famous book was called Social Statics by Herbert Spencer. And Holmes used this line because of its great alliteration, Herbert Spencer, Social Statics. But also, he was trying to make the point that the 14th Amendment does not embrace social Darwinism. This was an unfair criticism because nothing in the majority opinion embraced social Darwinism. In fact, majority opinion said that these workers wanted to work more hours to get ahead. This wasn't an attempt to exploit them. So the entire crescendo of the Herbert Spencer social statics is just a misnomer. This wasn't about social Darwinism. Perhaps most ironically, Holmes was a social Darwinist. So if anyone noticed, it said, if you did reading for Wednesday, you'll know that they recently upheld the Massachusetts vaccination law. Okay, that was a case called Buck v. Bell. I'm sorry, this was Jacobson versus Massachusetts. This law said that you could force someone to be vaccinated. Several years later, Holmes built upon that in a decision called Buck v. Bell. Those of you who read the reading for Wednesday. And what did Holmes say? If you have an imbecile, you can sterilize her. He upheld an actual act of social Darwinism, a clear and painful example where this poor woman, Carrie Buck, had her ovaries cut because she was deemed promiscuous. We'll get to that on Wednesday. But an economic theory, no, we can't have that, right? An actual constitutional clause which has a history of liberty of contract, oh no, we can't have that. So pardon me if I'm not bowled over by Justice Holmes' mellifluous dissent. I think it's a lot of hot air. Let's see what else. He also says, this is not about laissez-faire. People have different views. He says, I think the word liberty in the 14th Amendment is perverted when it perverts the natural outcome of dominant opinion. So whenever courts want to use the 14th Amendment to conflict with majority opinion, they're wrong. Holmes does not think the courts have any role in invalidating laws. He was a judicial restraintist of the highest order. And as you'll read in Wednesday, if there's no better example, he upheld a law that forced sterilization. And he seemed gleeful at this, saying, yes, if the people want to cut umbilical cords, go for it. Yeah, cut away, girls, right? So he did not think the courts had any role to invalidate these sorts of things. The one exception is that later in his career, he came around on free speech, very late in his career, and he found certain laws that violated the freedom of speech. But for the most part, he did not want to do this. We mentioned before Robert Bork. Oh, no, sorry. We'll get to Bork in a second. Holmes once said, this is my favorite quote, "If my fellow citizens want to go to hell, I will help them. It's my job." Say it one more time. If my fellow citizens want to go to hell, I will help them. It's my job. He believed in majority rule, that whatever the majority voted for, then that's it, and the courts have no role of intervening. And Robert Bork, who we've discussed before, was President Reagan's nominee to the Supreme Court in 1987 or 87, was very much in the spirit of Holmes. He once said in his book, Tempting of America, "In wide areas of life, majorities are entitled to rule if they wish, simply because they're majorities. Bork wrote, just because the majority, they can do as they wish in almost all areas, unless there's a specific constitutional prohibition. The Liberty Clause of the 14th Amendment does not cut it. Okay. All right, any question about the actual Lochner dissent by Justice Holmes? Which again is viewed in any other law class, but this one is the greatest thing ever written ever. But I will respectfully dissent. Okay, so what happened afterwards? After Lochner, an era began, the so-called Lochner era, which is really a misnomer, and I'll explain why it's a misnomer. The book said that the due process methodology of Lochner reigned for the 3 decades. Okay, during that time, they struck down 200 laws. There are 2 aspects of this that need to be disentangled. So one, you have the due process clause, right, where many state labor laws were indeed validated, but many were upheld. There wasn't a clear rule one way or the other. But at the same time that we had these sorts of Lochner era substantive due process cases, we have the Commerce Clause cases, which we've already discussed, where the new legislation. And initially, resisting it. Cases like Schechter Poultry, 9-0, they invalidated the National Industrial Recovery Act. Because at the same time the court was invalidating laws based on substantive due process, they were also invalidating laws under the Commerce Clause, or the taxing power, or the 10th Amendment. People often mishmash these together. They're different threads. And just saying Lochner doesn't distinguish the 2. Because even if you disagree with substantive due process, the word commerce is in the Constitution, right? That one's a little bit more textually grounded. Okay? So there were a number of cases, I'll walk through them fairly quickly, where the court went on both sides of the substantive due process issue. A case called Mueller versus Oregon. I have a picture of it here. Yeah. Yeah, so this actually involved the Lace House Laundry from Oregon. It's up there. And this actually involved a law that said women could not work more than 10 hours a day. So Lochner said men can't work more than 10 hours a day. That law is invalidated. But this law, women cannot work more than 10 hours a day. This law was upheld. Yvette, what's the Baptist reason why women can't work more than 10 hours a day? Why do you think this law was upheld in 1908, whereas Lochner was invalidated in 1905, 3 years earlier? What do you think of it? Why do you think women were treated differently here? What? Louder, I can't hear. What about families? Yeah. It was based on a stereotype that women couldn't work that hard. The idea was a woman's place was in the home. And one of the most famous briefs in constitutional history is called the Brandeis Brief, where Louis Brandeis, who would become a justice some years later, submitted a brief to the Supreme Court explaining why the state had a greater interest in protecting women. Remember, Lochner was good law. So they said, oh no, protecting men, they don't need it. They're strong, but women need it. And I swear, I'm not making this up. The Brandeis Brief argued that if a woman works too hard, her uterus will fall out. This was actually a legitimate thought of why women should not work hard and should not be in sports. There was actually a theory that if women participate in the Olympics, their uterus would fall out. Just hanging out, right? So the things you learn in ConLaw, right? The discussion, the opinion had an entire section on the physical difference between men and women. They're anatomical, physiological. Here we go. I'm quoting here. Physicians are agreed that women are fundamentally weaker than men in all that makes for endurance. Okay? Okay. So basically, they upheld a law restricting women to 60 hours a week. Go figure. The law was appropriate given, quote, the physical structure of women and the need to protect them, even when the legislation is not necessary for men. So they managed to uphold this under the police power because there's a stronger interest in protecting the innocent women working at this laundry house. Okay, there's another case in 1908, Adair versus United States. And this involved what's called a yellow dog contract, which basically means we only employ people if they agree not to join a union. And here Harlan, the dissenter in Lochner, said this law is unconstitutional. If a person wants to work somewhere where unions are prohibited, that's their freedom of contract. There's no good reason why to allow this. So the results were not consistent. Even Harlan, who had this, kind of a rational basis type approach, said, you know what, we'll pull this. The next case, Atkins versus Children's Hospital, 1923. This involved a minimum wage law in the District of Columbia for women, only women, right? This they invalidated because they said this interferes with women's liberty of contract. Unlike the Brandeis brief, here the court said that women are equal, that they have equal bargaining power, and they can negotiate for whatever wages they wish. Okay, so again, it's not a clear path. Buchanan versus Worley, 1917, is a case from Louisiana, from Louisville, I mentioned before, where the city segregated homes, saying a black person can't sell their house to a white person, and a white person can't sell their house to a black person. This violated liberty of contract. If I can sell my house to whomever I want. So even though Plessy versus Ferguson was still good law, equal protection didn't mean anything, you still had the liberty of contract to sell your home to whom you chose to sell it to. Okay? So basically, from 1905 to the 1930s, the case took a very, windy road between one case and the other, and they weren't able to come to a conclusion. But all that changed in 1937, a case I mentioned before. This was a so-called switch in time that saved 9. In the case of West Coast Hotel versus Parrish. This was actually a hotel in Wenatchee, Washington, where basically the state passed a law imposing a minimum wage for women. In Atkins, some years before, the court had invalidated a law saying women did not need help, they can negotiate their own wages. But in this decision in 1937, Justice Owen Roberts, not John Roberts, Owen Roberts changed his vote. And he voted to uphold the minimum wage law. And doing so, he signaled that the court would no longer stand in the way of progressive legislation. The court effectively overruled Atkins, and they said this decision was wrong. Okay? So after 1937, the idea of substantive due process was basically rejected. Why? Because it gets in the way of progressive legislation. And through the 30s, 40s, and 50s, the court continued to reject any notion that economic liberty was a fundamental right. And perhaps the most famous decision in this case is United States versus Caroline Products, the case I've mentioned last week. Now, this case is most known for footnote 4 of its decision. And the part of footnote 4 that Angela asked about last class involves political process, right? The idea is if certain laws affect, quote, discrete and insular minorities, then the courts have a heightened role for policing those actions. But the other part, the part that people don't ever actually study, most people forget about, but I won't let you forget, split our fundamental rights in half. They said if there's a right in the first 10 amendments, or if we deem it fundamental, it gets heightened scrutiny. All other rights get something affording rational basis scrutiny. So if it's in the first 10 amendments or the court deems it fundamental, it gets something like strict scrutiny. All the rights get crap scrutiny and they don't really matter. Okay? This split rights in half. And the key right they were thinking of was the right of economic liberty. This was a right that was relegated to a second-class status by footnote 4 of Caroline Products. And the actual facts of this case are actually really interesting. And I have some memorabilia, which you can come up and see if you want after class. In the 1900s, a new technology was created called condensed milk. This is where you remove the dairy from the milk and you replace it with some sort of vegetable oil. That way you can have milk that sits on shelves and lasts forever. This can expired in 2010, probably still good. Okay? You can drink it, I'm not. But I'll take your word for it, right? So there was one company, the Caroline Products Company in Litchfield, Illinois. And the owner is a guy named Charles Hauser. And he was intent on selling this product. But unfortunately, many states and the federal government passed a law prohibiting the sale of filled milk, right? It's called the filled milk case. Why? They said, well, it's unhealthy. There was absolutely no evidence that this was unhealthy. In fact, this stuff is even healthier than real milk because there's no cholesterol in it. They didn't know what cholesterol was. But they had all this junk science saying filled milk was bad for you. As an extension of this, margarine was an existential threat to dairy producers. A law was passed saying that margarine must be dyed pink. Why? So people won't buy it. They think it's gross. If margarine is dyed the same color as butter, people won't know the difference. So Charles Hauser, and by the way, this is actually a recipe book from 1937. You can find these on eBay if you are obsessed like I am, which I am. You can actually buy these recipes online. This is actually a picture of Hauser. And I actually had the honor of speaking, I think, with his granddaughter or his niece on the phone. And by the way, this is his factory. Okay? This is his factory, which is on the state line between Illinois and Oklahoma. Okay? The state line's right here. I'm sorry, between Missouri and Oklahoma. The state line's right there. Does anyone want to take a guess why he built a factory on the state line? I want to take a guess. This guy's really smart. Think at Commerce Clause.
Wouldn't fall under any state law, it'd be federal, because interstate commerce.
No.
And you could do business in both
He built a factory in the state line so he could do business in both states. Because there was a ban on the interstate shipment of commerce. So what happens is he had shipping doors here and then shipping doors there, both sides of the state line. The story is there was a brass rail that went across the state line, and you were never allowed to transport the filled milk across that brass rail. Now, there's a family legend that's almost certainly not true, but the granddaughter told it. I don't think it's true. But apparently, at one point, the grandfather drove a milk truck into West Virginia for the purpose of getting arrested because he wanted to challenge the constitutionality of this law. So I actually read the indictment. That never happened. But he was indeed he was arrested. He didn't drive the milk truck, but he was arrested. In one of the more crazy instances, the Supreme Court upheld his conviction. But this is awesome. Shortly after the Supreme Court upheld his conviction, President Franklin Roosevelt pardoned him. So the guy who was a thorn in his side challenging the stupid filled milk was pardoned by Roosevelt. And this was issued about a month before Roosevelt died. This might be his last pardon or one of his last few pardons. And here, yeah, you can see his Roosevelt signature right there. Anyway, why am I dwelling on this case? Because Caroline Products basically signaled the end of any sort of scrutiny for economic liberty. After this case, the courts would not give economic liberty any sort of scrutiny, and this built up this mythical status of Lochner as this evil case alongside Korematsu. Okay, and then in a series of cases in the 1940s and 50s, the court made clear that not only are we going to be applying a rational basis test, we're going to just do whatever the government wants. Okay, we're going to just defer to everything. So in one case called Williamson v. Lee Optical, 1955, Oklahoma passed a law that said if you want to fit glasses, right, actually just make the lenses and put them in the frame, you need to be a doctor. You need to be an ophthalmologist. Do you need a medical license to put a frame put the lens in the frame? Of course not. This law was clearly aimed at protecting the ophthalmologist. This was Lee Optical, if anyone knows, it's like LensCrafter, or like Pearl Vision. It was like a place that would open up in a shopping mall, make it easy to get glasses. They wanted to put these places out of business. You had to go to a doctor's office to fit lenses. The court upheld the law, and the court said the day is gone when this court uses a due process clause to strike down state laws because they may be unwise, improvident, or out of harmony with a particular school of thought. So in Lee Optical, the court said, we're not going to strike things down basically for any reason. And then this came for a super crescendo in a case called Ferguson versus Skrupa, S-K-R-U-P-A, in 1963. And the court infirmly rejected Lochner, and they said, we refuse to sit as a super legislature to weigh the wisdom of legislation. And what's important about Lee Optical and Ferguson v. Skrupa is it was no longer necessary for the state to give any reason why the law was enacted. The court basically said, even if the government doesn't give us a reason for why they acted, we'll make one up for them, right? Even if Oklahoma can't give a good reason why opticians cannot fit lenses, but ophthalmologists can, the court will make up a reason. If you are ever litigating the rational basis test, as it's called, you're in a tough spot. Because no matter how many arguments you put forward, after you submit your briefs, the court can make up another one to explain why you lose. Okay? And indeed, the courts makes it clear. You have to negative, or you have to veto every conceivable rational basis on which the law can be upheld. Every reason the court can make up, you need to counter. It's impossible to counter a reason that you don't see because the court only raises it in the opinion after the briefs are submitted, the arguments are submitted. So arguing under the rational basis test is basically impossible. Okay? Economic liberty, for the most part, the casket case, the flower case, the eyebrow thread case, the eyebrow threading case, these are outliers, right? These are not normal. These are the rare exceptions. In virtually 90-something% of the cases, in economic liberty cases, the government wins, almost always. Okay? So why were all these things being built up? To stop the New Deal, to stop attacks on progressive legislation. Okay? But here comes the big but. What about abortion? This was the issue that was lurking through the 50s and 60s, and people knew it was coming. States had no interest in allowing abortions, but various groups did. They would have to turn to the very same doctrines that justify Lochner to justify Roe. And this is an inescapable fact, which if you ask any other law professor, how do you have Lochner and not Roe? They'll say, oh, well, abortion is fundamental. Says who? Under footnote 4, the court says courts decide what's fundamental, but that's an artificial distinction. So it's a very uneasy pose of how you can have a hatred of Lochner, but a fetish of Roe, if I may.
All your segregation cases and things like that fall into the same measure.
Well, segregation is based on equal protection, which is an actual textual link in the Constitution. It's equal protection of the laws. Liberty is much broader because it doesn't really have a definition. Any other questions? All right. I'll see you all on Wednesday. Thank you.